The hearing will start now. This is originating applications 381 to 385 of 2022, summonses 3866 to 3870 of 2023, Zipmex Company Ltd and other matters.
Good evening, Mr. Tang and Ms. Wee for the applicants. Correct.
Yes, Your Honor. Good evening.
Good evening. And for Mr. Richard Chua, Mr. Justin Yip, Mr. Lam, and Ms. Chiang, correct?
I confirm that, Your Honor. Good evening.
All right. Ethics and lease is noted. All right. Thank you for your submission. Oh, sorry. Let me admit to the Zoom allocation first. So parties are reminded there is to be no unauthorized photography or recording in any form and no dissemination of any photographs or recording of these proceedings. And only those counsel or persons notified to the court should be present at each location, and parties should treat these proceedings as they would a physical hearing. Right, good evening. This is for my decision in the case. I received a letter from the applicant's counsel enclosing an Indonesian law opinion, but as I've indicated, leave should have been sought. But in any event, I do not think it will be material to the proceedings, so I don't propose to deal with the contents any further. Now, I will now read my remarks. So the judgment will be available to parties after this evening, and I have some introductory passages which I will omit. So I'll proceed directly to my decision and begin at paragraph 14. Now, I note that the main difference between the parties is their position on the jurisdictional objection raised by the objecting creditor. The question that arises for determination is thus whether the court can grant an extension of moratoria under Section 64(7) of IRDA, where, as in the present case, the applicants have proposed schemes of arrangement that turned out unsuccessful and where there is no further prospect of restructuring. For the reasons that follow, I agree with the objecting creditor's jurisdictional objection and dismiss these applications as they lie outside the statutory framework under Section 64 of IRDA. Now, under that section, where a company proposes or intends to propose a scheme of arrangement between itself and its creditors, it may apply to the court for an order imposing a moratorium on proceedings against it. And unless the company has previously made an application under Section 64(1) within 12 months prior to the date of the application, the filing of a Section 64(1) application itself triggers an automatic moratorium that remains in force until the earlier of either 30 days from the application or date on which the application is heard or decided by the court. Thus, to summarize, under the IRDA scheme, where a company makes an application under moratorium under Section 64(1), an automatic moratorium generally comes into effect under Section 64(8) and 64(14). If the court decides to grant the application, it may extend the automatic moratorium for such period as it thinks fit. And if the company considers the period ordered under Section 64(1) to be insufficient, the court may grant subsequent extensions of that moratorium under Section 64(7). So on first impression, given the framework that I've outlined above, it would seem clear to me beyond peradventure that any extension of moratorium under 64(7) can only serve the same purpose for which the moratorium was granted or first extended. Now, thus, any moratoria granted under Section 64, whether under 64(1) or 64(7), must be concerned with the making or proposed making of a scheme of arrangement. I nevertheless do go on to consider the matter further. In order for the court to grant an application under 64(1), there are both procedural and substantive requirements that must be met, and these are set out in 64(2), 3, and 4, and I need not set them out in full. However, it is clear on the face of these provisions that their purpose is to confirm that the company is in the midst of or intends to undertake a restructuring exercise. I can give two examples. First, under 64(2)(b), the company is required to make or undertake an application to convene a scheme meeting under the Section 210(1) or to approve a prepackaged scheme under Section 671(1) of IRDA. Secondly, under 64(4), the company is required to produce evidence of support for the proposed scheme or evidence of support for the moratorium. And this is from the case of Skaugen. On the substantive front, the test is whether on a broad assessment there's a reasonable prospect of the proposed or intended scheme working and being acceptable to the general run of creditors. And again, I cite Skaugen. This makes clear that the moratorium is intended to facilitate ongoing attempts or the intention to restructure. These requirements are tried in respect of the application 64.1. The critical question is whether, as a matter of construction, the court's power to extend a moratorium under 64.7 is circumscribed by these same requirements as its power to grant a moratorium in the first place. The Zipmex Group urges the court to answer this in the negative. Their submission is that, given the generality under which Section 64.7 is worded, the court's power to grant an extension under 64.7 is disconnected from its power to grant the initial moratorium under 64.1. Thus, the requirement of an existing prospect of restructuring that is integral to an application under 64.1 does not apply to an application under 64.7. Instead, they submit that 64.7 confers on the court a broader discretion that's to be constrained by the following factors which they identify as relevant to their situation. Firstly, that rights and prejudice occasion to the creditors should the extension be allowed or conversely not allowed. Second, whether the application has been brought bona fide, which is a multifactorial assessment conducted in the particular context of each case, referring to Skolgan. And third, whether there's creditor support for the extension of the moratorium. I do not accept this submission. There is nothing on the face of 64.7 that suggests with any degree of persuasiveness that the court has a freestanding power to extend a moratorium for a purpose other than that which led to it granting it in the first place under 64.1. I note that the procedural requirements in 64.2, 3, and 4 contain an express reference to 64.1, but not 64.7. However, I am not convinced that this is of any significance. It is clear to my mind that the absence of any reference to 64.7 in these provisions, as well as the generality of 64.7's wording, is not in itself specifying any requirements, and both readily explicable by the draftsman's reasonable expectation that 64.7 will be read as part of 64 as a whole. If 64.7 was really intended to create a freestanding power of extension, unconstrained in any way by the rest of Section 64, one would expect it to have been hived off into a separate standalone provision. I am buttressed in this conclusion by the fact that the Zipmex Group has not been able to identify this statutory footing for the factors as cited as its proposed parameters. They have tried to extract these factors from judicial statements and case law. That attempt has not been convincing. In my view, the far more logical inference that is to be drawn in respect to the lack of any restriction or modifier within the wording of 64.7 itself is that the draftsman did not think it necessary, given that the location of 64.7 as part of 64 speaks for itself. And I cannot glean any intention that an application of 64.7 is intended to be governed by different principles than one under Section 64.1. I also find support for this approach by examining the analogous context of judicial management under ERDA. A judicial management order similar to 64.1 also involves a moratorium restraining proceedings against a company under 96.4, and the similarities do not stop there. As is the case with an application of 64.1, an application for judicial management order also triggers an automatic interim moratorium pending the court's determination. And apart from the structural similarities, perhaps the most crucial point of identity is that both regimes are intended to achieve specific purposes. Whereas the moratorium under 64.1 is intended to facilitate a proposed or intended restructuring, a judicial management order is granted to achieve one of the aims of judicial management set out in 89.1 of ERDA. The continuation of judicial management is contingent on the continued pursuit or possibility of achieving these prescribed aims, since under Section 112.1 of ERDA, a judicial management manager must apply to discharge company from judicial management if one or more of the purposes under 89.1 has been achieved, or none of the purposes is capable of achievement. Thus, when an application is made to extend a judicial management order, the court must be satisfied that extension would be likely to achieve one or more of the purposes for which the order has been made. And this can be found in the case of the CNA Group Limited. The judicial management scheme thus stands an example within ERDA itself of the continued applicability of a regime being dependent on the possibility of achieving its purpose in a particular case at hand, and I see no reason why the same should not be the case in respect of the Section 64 moratorium. And applying the three-stage framework to statutory interpretation set up by the Court of Appeal in Tanjung Bok, it is clear to me that this is a situation where the ordinary meaning of the provision, taking into account its context, admits of no ambiguity or obscurity in terms of possible competing alternative interpretations. Thus, extraneous material will only be admitted for the purpose of confirming the ordinary meaning of the provision. My conclusion on both the text and context of 64.7 that the court's power to extend the moratorium cannot be exercised other than to facilitate the proposed or intended restructuring is reinforced by the objectives of the moratorium regime. At the second reading of the company's Amendment Bill 2017, the Senior Minister of State for Finance, Ms. Indrani Raja, Senior Counsel, introduced the moratorium in the following terms. First, the moratorium. These provisions will allow the court to order moratorium in favor of a company that's proposing or intends to propose a scheme. The moratorium prevents creditors from taking action against the company, such as commencing legal proceedings or enforcing security rights, and gives the company breathing room to put forward the restructuring proposal. End of quote. This explanation confirms that the purpose of the moratorium is to facilitate attempts at corporate rescue, and it follows once it is considered, as the Zipmex Group has done, that there's no further prospect of rescue, the justification for the moratorium's continued operation falls away. And Justice Kannan Ramesh's Galgan expressly tied the court's powers to grant extensions of moratorium to the existence of continuing prospect of restructuring. And I cite him at paragraph 42, and I note that I agree with that linkage. Turning then to the earlier authorities, I find that my interpretation 64.7 is also confirmed having regard to existing authorities, in particular where those extensions were sought but not granted. The Zipmex Group has attempted to downplay the significance and or weight of these earlier authorities on the basis that they did not involve the specific situation at hand. However, the objecting creditor places reliance on my earlier decision in Re Equibus, and similar to the present case, Equibus concerned applications by a group of companies for extension of moratoria, and I dismissed these applications as I was not satisfied that there was a reasonable prospect of the proposed scheme of arrangement working. Although not cited to me by either party in Real Lima Agramont Private Limited, 2023, Singapore High Court 236. This case provides another example. In that case, Justice Hari Kumar dismissed an application for second extension moratorium because there was clearly no progress in the applicant's restructuring efforts or a reasonable prospect of a scheme of arrangement being successfully proposed. In my judgment, if it is settled, the court would decline to grant an extension if it is not satisfied that there is reasonable prospect of a proposed scheme working. It does not make sense for the proposition to be different, whereas in the present case, a scheme has already been proposed, failed to pass, and it is now conceded that there is no prospect of further restructuring. Indeed, the same conclusion must follow for sure. Right. So for all these reasons above, I dismiss the present applications, and in closing, I make two observations. First of all, I appreciate that various other alternatives, ranging from other mechanisms such as the appointment of interim liquidators or judicial managers to individual injunctions being taken out against creditors seeking to wind up the company, may not be viable in terms of cost and effort. The lack of any alternative does not in itself allow the court to conclude that the applications prayed for should be granted. Second, all things being equal, the court does aim to be facilitative and lean in favor of restructuring and rescue, especially where there is no untoward prejudice to any particular creditor or other stakeholder. However, once again, such facilitation must occur within the parameters of the powers conferred by the legislature on the court. Although lack of prejudice to creditors is certainly a consideration of signal importance, lack of prejudice or even some avert benefit to creditors is no substitute to a sound legal justification. Thus, even if the court may have some sympathy to the commercial objectives that the Zipmex Group have articulated in these applications, these do not supply the necessary legal basis for the court to exercise the power that has been invoked. Now, finally, as regards to post-hearing attempt at further submissions and evidence, I will underline yet again that counsel should not send in, without leave, any further submissions or evidence after the hearing has been held and judgment reserved. The court's leave should not be presumed. The opportunity was previously given to parties to deduce evidence and present their arguments, and the court was already weighing those arguments in the course of rendering its decision. The interlude before the pronouncement of the decision was not an invitation to rush out together additional materials and to render the court spending deliberation a waste of time. There may be situations in which some justification exists in making it necessary for a party to ask for an opportunity to have another go after the hearing. Leave should be sought. I will leave it at that in the present case, but in future instances, in any other case, may merit a more substantive response from the court. For completeness, I should note that the contents of the Indonesian law opinion here are irrelevant to the outcome here, as is evidence to my reasons above. So given my decision to dismiss these applications, the moratorium in favor of the Zipmex Group will not be extended beyond today. So that is my decision. Mr. Tang, anything further on your side?
Yes, Your Honor. Thank you for the decision and for taking the time to hear us today. I am instructed, albeit with not a high anticipation of success, to ask if Your Honor will consider extending the moratorium for 6 days while we take instructions on appealing this decision.
All right. Mr. Yip, Anything in response?
Your Honor, I struggle to understand the legal basis for that. Any extension on Your Honor's part would be contrary to the reasons why Your Honor dismissed the extension application in the first place.
All right.
If my learned friend wishes to seek a injunction in the midst of an appeal, that would be, as Your Honor has pointed out in this and previous applications, a separate and distinct civil procedure process.
All right, Mr. Tang, anything further?
No, Your Honor, I leave it in Your Honor's hands.
All right.
Yeah, Your Honor, if
I-
I can just add on the last point, I apologize. Our response is again only in relation to Zipmex Private Limited, OS 382. I take no position on the other four if Your Honor chooses otherwise.
Yes. All right, of course. All right, I do not think, Mr. Tang, that it would be appropriate for me to grant any such injunction, so I must decline.
Understood. Grateful, Your Honor.
Right, good. All right, thank you. Nothing else, I think, from anyone? If not, right, thank you for your assistance in this matter. Good day all.
Good day, Your
Sure.
Honor. Thank you.
Right, thank you, good day, thank you.
What is it?
Yes, Joe.